Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem under the name ThATuMBRELLAgUY. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me. I'm a man.
Police or zombie problems? Your tortoise won't stop breakdancing?
Try blue tape.
The miracle of our age. Yay!
Like my coffee, extra mad and bitter. And then they're loyal like juicer, yeah, the man's a quitter. He's strapped face up behind the platinum grill. I style faceless, just spit these mic skills. And in the street killer, I will not be denied. That I'm mic'd up, I raise my head with pride. A force of nature cruising the whip, doing walk-bys on your boulevard. Face my verbal clip. In this land of live streams, baby, I'm on the road. Got my feet on the media, scraping them up my soles. It's that umbrella guy facing the accusers. Cleated out size 14s, crushing all those losers. It's that umbrella guy, they said we couldn't make it. Never ask permission, just sense I'll go and take it. The media buzzwords, they will never save you. Listen and believe it's meant to enslave you. Challenging the hypocrites, and baby, I'm on fire. They flash titles like they're royalty, but it's true that I'm a journalist. Scribble nursey rhymes, one in this grill in a basket, with a tisket and a tasket, and their morals in a casket. No morals in a casket. They're always pushing make-believe and weaving straw to gold, but I'm sick of all the fairy tales and buying what I'm sold. Strolling into the backyard, taking truth on tour, baby, there is sickness, and that umbrella guy's got the cure. Look, it's that umbrella guy knocking at the door. No more ministry of truth than the plot of 1984. I'm dumping all my verbal clips, the cases filled with knowledge. They're on the mic like kindergarten, and I'm taking them to college. Why the mask, baby? Cause this has to be a crime. I'll take the mic and boom, there in the chalk outline. I used to throw up elbows, but now I'm dropping nukes. You wrote another hit piece, isn't that cute? And the worst part, they'll never learn it before the stakes start channeling, crash and burn. They pretend that we need to get their permission. That umbrella guy crushing their ambitions. You're not my competition, it's that umbrella. It's that umbrella guy steamrolling them out for fun. Mic check, mic wreck, paging this army of one. There's no hesitation, no doubt, not even a scintilla. The Tokyo
All right, what's up, folks? How's it going today? Welcome to a very interesting one where we actually get a response today from. I actually called him. I noticed it is. I called Dan Owens a district attorney, but actually he is. What is he? He's part of the chief assistant state attorney. He is. Let's look at his actual title. Let's get that right. Give me 1 minute. He is the division chief with Levy County. So under his, let's see, under his purview, I like how they guarantee, by the way, that they prosecute everything to the fullest. And yet, I was looking at the layout, how this is worded, considering, with the whole office there, and how they tell you that investigators, when they're assigned, they go and they always use victim advocacy. You'll notice this with every place that ever talks about what they're going to do. They're advocates. They always stand up and they always do what's right until they get in office, and they don't. But we have an answer from ye old Dan Owens in the case. That's right. And as part of that, of course, now with this, of course, you knew that they were going to ask for dismissal. They would have going to ask with prejudice, not without, so it could be refiled. So they're going to ask with the prejudice on that. And with this being in that court so far, again, for me, I have the expectation. It's kind of like when you're asking the state to police itself, and they're not very good at that. So it will be very interesting to see how they respond to everything. Given, again, you're asking them to, quote unquote, do what's right. A lot of times when you ask them to do what's right, like I said, you end up a lot of it on, you end up with that on the appeals track, because these people, how often do you actually see them doing what's right? It's fascinating too, considering what they had to say about it. They seem to want to act like, hey, nothing's the matter here. We didn't do this, or we didn't do that, or we didn't do the other. And it's a really fascinating document when you get into it. Very fascinating. Hey, what's up, man? What's up, Travis, by the way? Glad you're on tonight, brother. Been a painful day, man. You know what? I had I had a very interesting day. I went and kicked it with the littlest one, with her. I took her out, and we ended up I took her to a toy store. I took her to look for something for Christmas as well. It was fun. I had a good time with that, and it ate up a lot of the day, but I was like, you know what? I'm definitely getting in here also tonight and doing what needs to be done. And I think that will be fun. We're gonna have a good old time, and we're gonna talk about all the stupid that these people have been into. Because at the end of the day, they can deny everything they want, but we've seen how they treated a protective order. Protective order is pretty basic too. I mean, if you have, you got to remember something. If you have a protective order, it has an inflexible rule in it. We've got a distance. Well, actually, let's pull a protective order when we're talking about this. Let's make sure that we understand it 100% here. I mean, it's pretty freaking easy to understand. So, maybe 1 minute. We had all of the we had all of the basic information attached to the thing. It tells you, what I love, by the way, is the people that here, let's pull this up here. People that talk about it a lot. The people that apparently aren't supposed to. It has all the rules laid out. It has distance laid out. It also tells you a wonderful thing in this, that the protective order is enforceable in all counties in Ohio, 50 states, District of Columbia, tribal land, etc., etc. So, when it's laid out, it's pretty cut and dry, and it's enforceable everywhere. They should understand that. Not very hard to understand, right? And yet, when you get down to it, I mean, they, again, remember, one of the main things that is at root in the discussion, well, there's actually two things in there. There's this wonderful thing with our wonderful undersheriff and Dan Owens talking about the order of protection. And here, we'll just read this and we'll see how they respond to everything. Like I said, can you email me the petition that redacted filed in order to obtain the order of protection? If you don't have a copy, please request one from the clerk of Summit County. I want to see if he committed perjury in that petition. Specifically, I want to see what representations he made with regard to Redacted's residence. My understanding is that Redacted has no ties to Ohio, much less Summit County, Ohio. Crazy. Like I said, Dan Owens wanted to, you can tell this is a request to investigate a person that is taken out of protective order. Do you ever see people trying to get you for perjury when obviously another state, their court system, they deemed that was 100%, and yet you have this guy stepping in, and he's like, oh, you know what? I want to instead of enforcement, I want to investigate. And of course, we have that other wonderful document as well, which you can look at with a wonderful police report. You can see the discussion of when it talks about occurrence, when, and the narrative. Look at the wonderful narrative here. Yeah, what a wonderful narrative, by the way. On 11/20/2023, I made contact with George, my phone, at her request. She advised today that at 15:30 hours, she was at the post office in Otter Creek, Florida. She stated that LMNOP, she saw her car, drove into the parking lot, and exited her vehicle. Miss Preston did not make contact with George. Again, you got to remember, protective order is not just about going and making physical contact. It's about distance. And it's about, again, when somebody steps into that area, you are violating. It's very basic. Again, we looked through how that works. There are specific distances. The whole we've heard the ecosystem talk about it enough. 10 feet, 10 feet. So you know how that works. Well, when you go through again, didn't make contact, entered the post office, checked your box, left the premises. George had witnesses to the event, including 2 employees, 1 volunteer. George stated that she has an injunction against, I love how they put it, against her again, herself. What a lovely typing job. George stated that she has an injunction against George out of Ohio, which, yeah, what it's supposed to say. I reviewed this is the important part, with the state attorney's office, the assistant state attorney, email regarding this matter. It reads that he would caution against enforcing this injunction. Again, it's pretty fucking cut and dry, So I wonder what he has to say about that. I wonder indeed. Let's check this out. So as far as this, again, as I said, I put in the title, district attorney. And, for some reason, I don't know why. but he always sticks in my mind. He was, if you look up, you can actually find video with Dan Owens years ago. I think the reason that that I think about it is I think about some of the, like I said, some of the stuff that where he's worked in the past. And again, with a lawyer, the difference is that like between a DA and a state attorney, the lawyer representing the state and local criminal cases is a DA. And depending on the state, these attorneys go by other titles such as prosecuting attorney, and you can go through again district attorneys and who they are, for states versus there's a pretty good breakdown of those if you ever want to know the difference. But really, again, titles signed. There's a lawsuit. The lawsuit, I think, brings up some important matters that should be discussed. And yeah, again, this pops up. Now, I was out today, like I said, and I brought all of that up to note one really important thing, and that is thanks to the folks that sent this. We have, again, Max Lab was on his best game today and popped this over. I saw that pop up from him before anybody even noticed it. That boy has the eagle eye. So thanks to him. And remember, if one of the mods would put in the chat, he has a channel out there where he also puts the stuff up and he goes over documents and more. And he has the subscriber count, but he needs the hours. So let's give him the hours, And these people are so crazy. Let's check this out though, man. I swear, all of this stuff is so nuts. So we have, again, Jeremy and George versus Dan Owens. And, of course, this is very expected. There's a playbook, okay? So by the playbook, you're going to have the person representing Dan Owens. They're going to come in. The lawyer representing them. And of course, they're going to ask for this to be dismissed and this to be dismissed again with prejudice. This is typical. They might as well, again, they follow I mean, it really is a formula. Everything it's not surprising. Now, some of the arguments that they make in this, I'm like, well, that argument is kind of dumb, but this is, let's see, the person. So there is a notice of appearance in this as well. They came up with document 8, and again, that is much appreciated too. It was sent over. I'm going to read it to you so you know who is actually is making an appearance here. This would be Anthony Dean Johnson, Esquire, as counsel for defendants, Dan Owens. You know what I love about this, by the way? The state, when you try to hold them responsible for something, they essentially play with the coffers of you and I. They play with our money. They really, you and I, if we get into trouble because we do something stupid, then it's on us. But if these idiots, they get to play with a loaded deck, let's just say, So it's a lot. It's an uphill battle, and it's going to be an interesting one to watch out. So let's read this. So Dan Owens here, he moves to dismiss plaintiff's complaint under Federal Rule of Civil Procedure 12B. We have seen that many times, by the way, by now. At a certain point, I'm like, my God, if I hear some of these another time, I think I'm going to kick something. I mean, really, how many times have we seen Bruce throw in 12B? It amazes me, just to be honest. Like, there's a lot of people out there that are like, what does this mean, or what does that mean? Well, I think maybe you understand what 12B is by now, but it states that Mr. Owen is absolutely immune from suit. See, this is disgusting to me. You know, they plead immunity. Oh, I'm 100% immune to this shit, you know, which when you read through again, the arguments about immunity are really interesting. But the only people that end up immune from shit are the very people that seem to violate our rights so many times. Whether that, again, I'm not saying that everyone is guilty of this either, but I'm saying that you have police officers, when they get in trouble, when you see the horrible things that many of them do, what do? Oh, well, I'm immune to that. Judges, when they do terrible things, what do you say? I'm immune to that, and so on. It's absolutely disgusting. You know, there is immunity for a reason. But again, you end up having to fight the state and plead a case where I hate that. I think that there needs to be something much better, because the state, whenever something comes up, what they worry about is looking bad. They don't really, and this is my opinion, they don't worry about whether something is right or wrong most of the time. They worry about cover your backside. And it's kind of disturbing. It's kind of disgusting. You wish, you know, they would do something right. But of course, you're expecting that. Oh, I'm immune from that. Plaintiff fails to state a claim on which relief can be granted. That is cookie cutter right there. Again, that you will notice that in every argument that you see from anyone that gets sued, you will always see that. And the most disgusting thing that you ever hear is qualified immunity. Qualified immunity pisses me off. Again, that is 100% the backdrop for any of the people that, again, there are employees, but the state, the Fed, they've given themselves the ability to really not face repercussions unless, and it's very narrow, and you have to fight that. That's what I was saying about, you know, a lot of the times the fight doesn't come down to the initial case. A lot of times you see qualified immunity getting hit on appeal if, again, the state decides not to do the right thing at the beginning. And they don't a lot. They don't. So you're going to be in the long haul as we get into qualified immunity. If you really want to see something that's awful and needs to change, you should look up qualified immunity. A drink here. All right. So the background. Jeremy and George are involved in an ongoing civil domestic dispute with their part-time neighbors, non-parties, Lynette Preston and John Cook. I like how they just boil things down to, oh man, it's an ongoing civil domestic dispute. You know, there would be some criminal issues, by the way. Dan Owens, I believe, if you guys would step up and prosecute him for certain things. But what do I know, right? What do I know? Anyway, let's continue. Plaintiffs primarily reside in Ohio, but owned property in Levy County, Florida, across the street from Preston and Cook. In September 2023, Preston filed a petition for a temporary restraining order in Levy County, case number blah, 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 against Mr. Hales. Oh, let's read this footnote, by the way. Plaintiff's current counsel represented them in Levy County proceedings and then later filed a federal lawsuit. Okay, let's see how that goes. Now, around the same time, plaintiff filed a petition for restraining order against... I like how we we get a pretty cut and dry. I'm gonna say a rehashing of this. You're like, you know, how did filing go? Who tried to file? What happened if Hales tried to file with Florida? Okay, but at the same time, Plaintiffs filed a petition for restraining order against Preston and Cook in Summit County, Ohio. Summit County, Ohio civil protection order was issued November the 1st, 2023, and expired October 10th, 2025. Now, Levy County temporary injunction for protective order against the Levy County temporary injunction for protection against stalking was issued on December 4th, 2023, and terminated at Preston's request on September the 4th, 2024. Right there. That is egregious as hell, by the way. You know, there's the key word in this, temporary. You know, while we sort things out, I love how they, by the way, I love how when they put this together here, how it makes it sound like both of them had restraining orders, but that's actually not the case either. Again, it's all in the wording, but it's so bizarre to read because again, it makes it sound like, hey, you know, they both got restraining orders against you. No, that's not actually how it happened. You know, Levy County decided, oh yeah, here's a temporary one, you know, something that's supposed to decide itself within a few days, not long. And yet, look how long it took. This by itself is disgusting. It's also disgusting that this happens. And yet again, look at how long this farce was allowed to stay in place. It's so gross when you look at it. Again, oh, that's... Talk about losing your rights. Not being able to freaking have your ability to protect yourself, to potentially not have a voice. I remember those times. I remember how when the grudge judge was part of it, it was so bad. Remember how that all played out? God, man. Anyway, I could rant all night about just this part right here, but I shall not, and I will continue because the grudge judge stuff, again, if people didn't watch what played out, this makes it sound again like, oh, well, both parties did X, Y, and Z. Yeah, that's not again not how it works. So George, Jeremy, they each reported violations of their protective order to the Levy County sheriffs. The 8th Judicial Circuit state attorney filed charges in Levy County, State v. Preston. What happened to all those, by the way? Oh wait, the charges were ultimately dropped. Oh, okay. That's fascinating, you know. Now, Preston and Cook also reported violations against Jeremy and George. Charges were brought and ultimately dropped or not prosecuted. Very sounds cut and dry, right? Again, this is why you have to keep up with this insanity yourself, because this is, oh man, you talk about some crazy. And then so plaintiffs then sued Preston and Cook in the Northern District of Florida, filed March 4th. Preston sued plaintiffs in Levy County. What happened to those, by the way? Well, let's continue first. Preston filed for Chapter 7 bankruptcy in the Northern District of Florida, resulting in the entry of automatic stay of plaintiff's federal lawsuit. A few months later, plaintiff filed the lawsuit against the 8th Judicial Circuit of Florida State Attorney Dan Owens for alleged failure to enforce the protective order against man. This right here, wow, that seems to leave out a little bit here, doesn't it? Were Preston sued plaintiffs in Levy County? Oh, that seems to leave out just a little smattering of what's going on there. And how really, again, if you start explaining where these cases are at this moment, what does it look like? You know, like if I were to drill down into these cases and I were to tell you they didn't just file one case, by the way. They filed multiple cases. They went out. They decided to dump them by the roadside like so much trash and set them on fire. They are now in trouble. And there's a lot more to it as well. But I digress again. It's a very simplistic and misrepresented way to look at some of that's going on. So the plaintiff's allegations. Plaintiff allegations here arrive from Ohio civil protective orders. Again, we have our docs there. That will be 1-1 and 1-2. Now, according to the complaint, plaintiffs were in Florida on at least 3 occasions between. They give the dates right there. Let's see. There's a footnote. On the footnote, plaintiffs appeared for several hearings in Levy County protective order, case number blah, 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 during this time. Okay. Plaintiffs brought the protective order to the Levy County Sheriff's Department and requested enforcement. Now, Levy County officer, we've heard this guy a lot, Mr. Undersheriff, emails Mr. Owens for assistance. Mr. Owens is currently a division chief for the 8th Judicial Circuit state attorney. In an email to LCSO, Mr. Owen wrote, wait a minute. So the LCSO writes Mr. Owens. Okay. Mr. Owens writes to the LCSO. This is, it almost, the way that it starts out, it almost sounds like, again, you notice they didn't put a header on this or anything. When you read this, it's so bizarre because the first time I read it, I was like, are they saying that that the undersheriff wrote this? That's again, just when you look at this line right here, the way that this leads off at first, it feels like that's what it was saying at first. I thought, wait, no. Mr. Owen wrote. He said, again, we saw this. Can you email me the petition that redacted, filed in order to obtain the order of protection? If you don't have a copy, please request one from the clerk of Summit County. I want to see if he committed perjury in the petition. Specifically, I want to see what representations he made with regard to Redacted's residence. My understanding is that Redacted has no ties to Ohio, much less Summit County, Ohio. Now, when George requested enforcement, now that's just so bizarre that the way that this comes up here. So, when George requests enforcement several weeks later, on November the 20th, 2023, a different officer, this will be the officer I was talking about with the document that I pulled up at the very beginning, because I wanted to pull these both up so you saw them fresh, wrote an incident report stating that he had reviewed Mr. Owen's email and, quote, it reads that the defendant would caution against enforcing this injunction. Now, Officer Williamson informed George that a report would be created for documentation only. Now, on at least 3 later occasions, though, as described above, LCSO responded to plaintiffs' reports about protective order violations, resulting in charges against the restrained parties. Okay. What now? Like, when did anything happen to them, though? That's been the question of it. Now, the plaintiff claims that Mr. Owens' investigation into the protective order amounted to a refusal to enforce the protective order, and that Mr. Owens' investigation caused physical harm, threats of harm, causing mental and emotional distress because of the restrained non-parties' intimidating and threatening behavior, like assault with a yeo pew pew, by the way. Let's see what's there. Cook was arrested and charged following an incident on July 3rd, 2024. What happened to Cook, by the way? What happens when there are arrests? Whatever happened to Cook? And why exactly doesn't anything happen there? Maybe we should refer to people like Patty and ask them what happens in Levy County when something goes on, especially with certain parties. Are you telling me that that's just standard operating procedure? I mean, again, that's kind of weird, isn't it? So disgusting, man. Now it's unclear again. Wait, with the gun. Let me not skip the rest. Causing plaintiffs fear of death, bodily injury from the restrained non-parties, obsessive behavior, caused financial harm because the restrained non-parties were emboldened. Oh, they very much were and have been. Now, it's not clear whether plaintiffs believe that Mr. Owen failed to take some action to protect them, that Mr. Owen is liable for LCSO's interpretation of the email as advice not to enforce the order. He's throwing the cops under the bus. You notice this, by the way? It's like, if you want to sue somebody, sue the police. That's what it sounds like. I don't know. That's their interpretation of it. Well, jackass, is that typical? I wonder, again, I get this feeling that we may have more correspondence. Do we, Dan? Do we have other correspondents there? What exactly are they referring to? Oh, well, if they interpreted it this way, well, jackass, again, when I look at even the one that we have available, I have never in my life seen somebody that has a protective order, and you're talking about investigating them for perjury. That is jacked up. That is next level. I have never seen anything like it. I mean, for real. And the weirdest part of that, again, you know how you find out about that? You find out about it because of a FOIA request. That how long did it take them to actually turn over that information, by the way? Were they forthcoming in it? Absolutely not. In fact, the way that they act about it, it would make a cautious mind feel conspiratorial. I would say it that way, because when I see the way that they went with that, I was like, how far would they go to cover their own asses? What kind of crazy thing would these people do because they have been caught? And they seem to, I don't know, not want to turn over stuff. Not only that, but remember, we have more FOIA information than that. And it is crazy to sit down and to read through the emails going back and forth for these people, and just to listen to them talk about Hales, period. Because when they talk about him, they're making comparisons to some criminal in the past, because the name is similar, therefore. I mean, it's bizarre stuff. And it would make you, when you're looking through it, think, wow, they're not only not going to protect you, but what length would they go to, again, to hide that? Would they want to treat you like you're the criminal party? I definitely would not say, I personally would never want to go near Levy County, ever. You notice people that are connected to Preston and Cook feel very safe in contacting, not only in going to Levy County and doing crazy shit, but also in contacting Levy County and doing all kinds of stupid and crazy things. We in fact, we saw proof of that in those. Let me see. We saw proof of that in the correspondent with Dan Owens. Remember, we didn't just have that. Let me see if this will pull this up. Give me 1 minute. If not, I may have to pull this up in a minute. You know, it depends on how StreamYard is going to act today. Yeah, here. This gives you an idea. So we have communication with Dan Owens. Like, look at this. This is assistant to Dan Owens writing, talking about 2L. Again, remember, we found this kind of stuff out. These people are so comfortable that they sit around plotting with his office, it feels like, trying to get Hales in them in some kind of problem. And they've said that they've done this multiple times. You know, they said that they've had many opportunities, which is fascinating to me, considering this is the same person that they're talking about, Lisa Lee, aka 2L. This is the same person that Preston says took $100,000 from them. They're calling in. Look at what they have to say here. This is back with November 2024. This was in the FOIA request too. They were talking about conversations. I'm unsure of where she is, but a fellow YouTuber, but rather is a fellow YouTuber. And it's disgusted that this keeps happening too. We know who Redacted and family are. They, unsure of who that is, just paid $5,000 to get them a privacy fence. And Redacted has moved cameras higher, up more than 10 feet, to see over the fence, basically stalking them, and then use it as content to get views and money for himself. She's looking at so many Florida statutes that show Redacted is breaking the law, and no one's doing anything about it. She asks what we need to prosecute the case against him, since all the others have been dropped, and stated whatever we needed, she'd be sure to provide. I explained we get cases from law enforcement, told her to contact them and file a report and provide all evidence to them. And it felt like, and if they felt like a crime had been committed, they'd forward to our office and also provide all the documents, videos, and information. She stated she was unsure who to trust because he's on town council now. What? Again, look at the fucking weird allegations here. And it's clear law enforcement hasn't gotten involved, hasn't done what they're supposed to. And this family's suffering and is being cyber stalked and harassed by a man. And she and others are tired of seeing this online content. That's just the conversation. It was mostly the same thing over and over. Subject YouTube caller. So they made sure to pass that on to Danny Dan. And he was like, yeah, you did the right thing. That's good to go. And then what did 2L say about that? Well, I've talked to them many times. In fact, I've talked to them in person. So you cannot FOIA those things. That's why I'm calling, because again, she made it very clear. Yes, I'm trying to plot and conspire with these people to cause Hales, who again has a fucking protective order in place against people from doing exactly this. That sounds like some crazy third fucking party trying to harass you. Excuse my language. You know, it annoys me when I see this insanity that these are the same people now that are calling Lynette Preston a liar and a piece of garbage and filth and all these other things. But just a few months back, you know, when it was convenient, by the way, you know, that was right before the barn dog grift. Or no, I take that. That was right after, you know. It was right after the Mondo grift kicked in. Right after it. I take that back. Remember the barn grift kicked in October. So, yeah. They had all that money rolling in. All those reasons to try to put somebody in jail. Because if they could have made that possible, then, you know, and again, they like to talk about they like to talk about reasons why. And like I said, we heard from 2L and the gang that they've done this stuff quite a bit. That's not the first time. That wasn't the last time, you know. And again, what was the date on that? That was what, 11? Give me 1 second before I pull up this other document here again. 1 minute. I'm looking on the date because I want to compare that to the earnings, you know. So that was written on November the 21st. And let's see, up till November the 21st. Well, wow. So just to give you an idea of the time period that all that stuff was happening at, by the way, let me pull something up for you here. Let me let you see this too, just to give you an idea of what was going on at that time period. Look at the amount of money that was rolling in for these people. That's when, of course, they were in it to win it for Lynette Preston, because she was one hell of a payday. You know, here's about, well, we'll just call it 12. Again, it's not exact, but we'll call it $1,258. You know, again, we have some change, but close, those two, right? We have 10, 20, there's $10,000, 11, 5, there's $20,000. Again, none of this turned over. 11, $13,000, 11, 17, $5,000. And then just a few days after that, $2,500 more dollars. So they had a lot of reasons to hope that Hales could, they could put his ass in jail. You know, because if they could make that work out for him, then it blows my mind. Some of the people that, God, that were involved in it, and they know, like I said, they seem to be pretty familiar with a lot of the stuff that was going on, and yet, I like that. I like how they were very familiar with protective orders and so many other items. Like I said, and yet. So the civil protection order, by the way, was 100% in effect when Lisa Lee and all these other rampaging morons were doing this. You know, again, this sounds like third parties trying to definitely give an earful, get involved in that, and yet, like I said, and yet, crazy stuff, isn't it? It's all crazy. This shit is so wild. By the way, it is a Saturday. There are almost 2,800 of you here. That is amazing, by the way. Much appreciated there. If you would tell people we are live and covering this insanity, that is definitely appreciated. There's about 20 pages of it. Oh my God, it's a bunch of lunacy, but it's definitely worth going over. If you would hit that like button, that is also appreciated. And if you would like to go further and would like to be like, hey, Tug, this is amazing coverage and you are the best ever. No, I'm just kidding. But if you would like to support the channel, hit that little super chat or send memberships, whatever you want to do. There are links too if you don't want to do it that way, and support the channel. Thank you. Let's continue now. So, you know what's crazy though, when you look at this again, it's like they again want to toss the police under the bus here. Like, Mr. Owen, he's not responsible for how LCSO interpretation of his email is advice not to enforce that order. Huh. He's not responsible that people wouldn't want to do that. I mean, that's not his problem. God, what a jackass, man. I hate this dude. I really hate this. Oh, thank you, Tizzy the Bounce. Thank you, all of you, by the way. That was the best ever. Thank you. Man, oh, that's nice, too. Oh, that's sweet. You have, oh, my God. Oh, my God. Again. 1 second. I've got to... Preston's asking for money again, $6,000 now. Oh, we've got another attorney, but we need $6,000. Well, you had $6,000, lady, but you pumped it into a freaking bankruptcy attorney that looks like the most incompetent little loser I've ever seen. So tough shit. Tough shit. Give us $6,000. No, thank you. What crackpots, man. Oh my God. For real, while this is all going on, while we're looking at this, she's like, we found an attorney and again are going to need to raise the amount of $6,000. Any help and blessing be so much, contact me. And, right now you can hook us up by a PayPal pool. Will be available soon, or Cash App, Venmo, PayPal, or Zelle. Holy God. It never stops, dude. These people never stop. Is that not amazing? I love it. Yes, she's also asking for stuff for the turtles too. I saw that as well. Yeah, she's busting out and being like, the turtles, they need some foods. They need you to hook them up. You know how I'd hook them up, lady? I'd say you give them to somebody that can take care of them. That's just my idea. But what do I know, right? What do I know? Anyway, let's continue. We'll look at that stuff tomorrow. And again, today, I just a note, I was planning on looking at how they're all taking aim at Silverman. We don't even know what the attorney's supposedly for. Who are they trying to sue this time? What are they trying to go after? Is it Ohio? Is it another? I mean, the last time they said they'd have an attorney covering something, 4 cases. What happened? It went into bankruptcy. Man, anybody that gives these people money is an idiot. They are an absolute idiot. And they are in bankruptcy while asking for people to donate out money. It's so maddening. It's so crazy. But anyway, let's continue. I could rant all night. We'll rant about that tomorrow. Nothing. This stuff never stops. You notice that? It's so crazy all the time. It is the craziest thing I've ever seen. So plaintiff brings 2 claims for relief. 1, failure to give full faith and credit to the protective order under 42 U.S.C. 1983. Again, this is very commonplace when you want to accuse any type of authority of doing some jacked up thing. That's exactly what it goes under. This is one of the only ways of holding them accountable. It blows my mind there. So let's see. We also have 2, violation of due process under 42 U.S.C. 1983. They seek compensatory and punitive damages, attorney fees and costs, and injunctive relief, requiring Mr. Owen to give full faith and credit to, quote, valid protective orders from other states and refrain from investigating the basis for such orders except as permitted by federal law. Oh, wow. What a terrible thing. Asking you to enforce freaking protective orders. What a monster. Holy crap. Jeremy Hales, you've gone too far. George, what kind of a demon are you? Asking them to enforce that? Levy County doesn't like to help out with the victims. I mean, they only have, when the baseline is 7% prosecution, and they only have a 3.75% prosecution in Levy County. Man, what do you think? So, although the complaint contains these claims and purports to describe damages, the allegations pleaded do not cogently support either the claims or the damages alleged, and the allegations conflict with the reality that the the circuit state attorney's office actually did bring charges against the restrained. Plaintiffs failed to state a claim because lawsuit lacks merit in fact and law, of course. This is, again, typical arguments. And again, you have to remember, it is an uphill battle. I think everyone involved understands that this kind of thing will be an uphill battle. It very much is. I'm really interested in seeing how this stuff plays out. So, standard. To survive a motion to dismiss, a complaint must contain sufficient matter to, quote, state a claim for relief that is plausible on its face. The plausibility requirement requires more than the possibility a defendant acted unlawfully. That's that's lovely too. I like that as well. I like the fact that, well, to survive this, you need more than the idea that the defendant here acted unlawful. Wait, what? I realize what they're going for. It sounds terrible when you think about what they're talking about. You mean a person who decides whether or not most people get charged with anything? I need more than to say that they're acting like jackasses and unlawful. I need more, And of course, yes, I know why. But again, it sounds so bad when you think about who is accused here. Quote, a plaintiff's obligation to provide grounds of his entitled to relief requires more than labels and conclusions, formulaic recitation of the elements of a cause of action. Naked assertions devoid of further factual enhancement and threadbare those of the elements of cause of action supported by mere conclusory statements do not suffice. Federal pleading rules require a complaint to provide sufficient notice to a defendant of the causal connection between him and the plaintiff's claim. Conclusory allegations that can be disproven by facts of which the court can take judicial notice. The conclusions are not accepted as true for the purposes of a motion to dismiss. So, memorandum of law. Mr. Owens is entitled to absolute prosecutorial immunity. Mr. Owens is immune to the claims that he failed to enforce protective orders. Quote, absolute immunity renders certain public officials, look how disgusting this is, by the way, completely immune from liability, even when their conduct is wrongful and malicious prosecution. Absolute immunity renders certain public officials completely immune from liability, even when their conduct is wrongful or malicious prosecution. Who do you think? Do you think the people went out and was like, you know what? I think we should protect these folks. If they go out and they do something wrong or they're malicious in that, they should get immunity. Does that sound like something the people wanted from their representatives, from the people that are supposed to protect you? Absolutely not. That is such a disgusting thing to read. But that's for real. That's how it rolls. Quote, having absolute immunity in civil damages actions, would it be a livable consequence if it could only be asserted when the defendant prosecutor correctly complied with all his legal obligations, in which case there would be no claim? As a preliminary matter, the full faith and credit clause does not mandate unquestioning obedience, nor does Section 1983 a strict liability statute. As described in Section 2 below, it is not likely that Mr. Owens' conduct amounted to a constitutional violation. Moreover, a prosecutor is not liable for every allegation that an action was unlawful or taken for a forbidden purpose. Adoption of this construction thus would deprive absolute immunity of its intended effect. This is some insanity. Now they're talking about presidential immunity, but they're like, hey, that goes with us too. Wonderful, isn't it? If we do terrible things, we're still immune to it unless it violates your constitutional rights. This is why when we talk about qualified immunity, we say it should be abolished. And people are like, you hate the police. No, you read what it does and what kind of defenses it's given. And they're like, oh, it doesn't matter if we did some terrible fucking things behind this because we're protected. What an argument, right? What an argument. But in this case, the Supreme Court determined that prosecutors enjoy absolute immunity from Section 1983 cases for activities that are intimately associated with judicial phase of the criminal process. This stems from a concern that harassment by unfounded litigation could both cause a deflection of the prosecutor's energies from his public duties and lead him to, quote, shade his decisions instead of exercise the independence of judgment required by the public trust. Yeah, so you know what? if I make a jackass of myself and ruin a few people's life, man, you know what? I should be protected. Amazing. Any other job, you would have problems. Any other job, you did something like this to someone, you would be in trouble. You'd have some real problems. But the state's like, nah, we're protected by the very laws that we create. It's lovely. Like I said, do you really feel like you're like you're protected here, man? But the 11th Circuit described the evolution of the Supreme Court's precedent on prosecutorial immunity, explaining subsequent Supreme Court decisions establish outer bounds on what activities qualify for prosecutorial immunity and to which individuals it applies. Prosecutorial immunity applies, for instance, to the prosecutor's actions in initiating a prosecution and presenting a state's case. The prosecutor is immune from malicious prosecution. Prosecutors are immune for appearances before a court and conduct. Think about that. A prosecutor is immune from malicious prosecution. I really want you to think about that statement for just a second. How horrible that is. Let me see. Let's ask a question. What is malicious prosecution? Just because. Malicious prosecution is a tort or a civil wrong that occurs when someone initiates or forms a criminal or a civil lawsuit for improper purposes or without probable cause, resulting in harm to the accused. So, hey, you go out with the intent to prosecute, or you don't do your job right. You do harm to a person, they're like, we can do that. We don't have to worry about that. Isn't that wonderful? I love this argument. It's great. It makes them look like really, really swell people, doesn't it? They're like, fuck you. Our job allows us to do whatever terrible thing. And it's like, okay, well, let's see how this goes. Like I said, this is why you end up, a lot of times, why you end up in an appeals court, because the state investigates thyself, and what do they find? Oh, we didn't do anything wrong. That's why you end up in appeals courts. But prosecutors are immune from appearances before a court and conduct in the courtroom, including examining witnesses, presenting evidence in support of a search warrant during a probable cause hearing. Prosecutors are also immune from damage claims alleging failure to institute a system of information sharing among deputy district attorneys regarding confidential jailhouse informants. Now, the 11th Circuit went on to say, applying these principles, our circuit has emphasized that a prosecutor enjoys absolute immunity from allegations stemming from the prosecutor's function as advocate. Okay. Such absolute immunity extend to the prosecutor's acts undertaking and preparing for the initiation of judicial proceedings or for trial, and which occur in the course of the role as advocate for the state. Prosecutors have absolute immunity when filing information without investigation, filing charges without jurisdiction, filing a basis tainer, offering perjured testimony, suppressing exculpatory evidence, refusing to investigate complaints about the prison system, threatening further criminal prosecutions. Wonderful. All right, you like that? Now, the determination of absolute prosecutorial immunity depends on the nature of the functions performed, not whether the prosecutor performed the function incorrectly or even dishonestly. Or I'm sorry, even with dishonesty. So it's look at this wonderful citation too. Well, you know what? We get immunity, not because it's because of the nature of what we do, not whether or not we did it bad, or even if we lied about it and we were dishonest. Isn't this a wonderful argument too? You like this stuff? This is what the state says, and they say it openly. Imagine if this is your defense openly, what kind of messed up shit you will do behind the scenes. That's why, again, they do not enjoy limitless immunity, though. That's the thing that you have to understand. When you read this, that's the way they like to present it. You cannot be prosecuted for anything. It's like, yeah, no. Remember that little constitutional caveat. But plaintiff failed to allege Mr. Owens engaged in functions normally performed by a detective or police officer. That's what they were saying. See, they were like, hey, Mr. Owens, he's going outside of his field. That you understand now why this allegation comes in. We were talking about this before. You understand why that happens, that he acted as a witness or spokesman or an advisor. Instead, plaintiffs allege without explanation that he failed to enforce the protective orders. Plaintiff do not even explain what action Mr. Owen, as state attorney, could have taken that he did not take to prevent the harm they allege. Third-party violations, protective orders. Maybe what could he not have done? I don't know. What's a weird thing that you might, like a prosecutor doesn't usually do? They don't usually look to prosecute the victims in cases. That's just a very strange way of going about it. And then furthering, did he step outside of his bounds as an investor? It'll be interesting to see the responses to some of this stuff. So the common sense answer, and one with the official prosecutorial capacity, is that Mr. Owens failed to bring charges against the non-party, a decision for which he is entitled absolute immunity, and a claim for which the plaintiff lacks standing, and an allegation that is rebutted by the facts of which the court may take judicial notice. And again, they note these these cases here, State v. Preston. What happened to those, by the way, Dan? Are we going to discuss that? What happened to those? Should we discuss what happens to those? I think that will be fun fodder to talk about. That will be. It's so bizarre that I can write emails and I can investigate the freaking. I can investigate the one party over here that we're supposed to protect. I can do anything I want. I'm a prosecutor. Oh God, man! Prosecutors are absolutely immune for liability under 1983 for the conduct and initiating prosecution and presenting the case insofar as the conduct is intimately associated with judicial phrase of the criminal process. Now, prosecutor enjoys, here's another, absolute immunity from allegations stemming from the prosecutor's function as advocate. Mr. Owens, I love that, by the way, they run on the idea that they're all advocates, but you know what? If you try to hold them to it, they're like, no. You can't sue us for anything that stems from the prosecutor's function as advocate. This should be in one of those wonderful commercials you see, when they're out there and they're saying, we will advocate. We do that. We advocate for all victims. That's what all prosecutors' offices, they run on. They always run on that. They talk about how they're out there, how they will advocate. They will give voices to the voiceless. But if they deprive the voiceless of their voices, if you try to hold them to that, no. Immunity. Love it. Don't you love it? So, Mr. Owens charging decisions, regardless of their restrained non-parties, were closely associated with the judicial activity of the criminal process, so he's protected by absolute immunity. The court should dismiss with prejudice. Now, number 2, plaintiff fails to state a claim upon which relief is granted. Again, Mr. Owen is the wrong defendant. Oh, okay. I wonder what this is going to state. I wonder if this is going to have somebody thrown under the bus. Let's see. That sounds weird, doesn't it? Plaintiff fails to state a claim against Mr. Owen because they failed to describe conduct by Mr. Owen that deprived them of constitutionally protected right. Instead, plaintiff complaint describes action and decisions by the Levy County Sheriff's Office. He throws the Levy County Sheriff's Office under the bus. He's like, fuck those losers. Oh my God. You suing the wrong people, man. Oh my God, that's amazing. Oh, I told you this is gonna be good. Holy God. You got to admit that's awesome. You know, that is awesome. It's not my fault, it's their fault. Oh God. Okay. I really love this. I love this document. You know, anybody who didn't make it to this far into the read really missed out on something. This is gonna get good. I hope everybody lets everyone know that Dan Owens, in his defense, threw Levy County Sheriff's Office under the bus. I hope they enjoy that, by the way. But they allege they, quote, presented the protective orders to Levy County Sheriff's Office requesting enforcement on November 20th, 2023. That's interesting, by the way, you know, because a year later, like I said, the Fats were calling in and being like, oh, you know what? We're gonna interfere with this person and try to get them arrested. Fatties, swear. And Williamson of Levy County Sheriff's Office created a police report for documentation only. While it might have been inferred that the Levy County Sheriff's Office did not act to enforce the protective order thereafter on Mr. Owens' advice, a fact plaintiffs have not alleged. Wait, what? While it might have been inferred that they did not act to enforce the protective order thereafter on Mr. Owens' advice, a fact I believe they did it actually. I believe that's exactly what they're saying. That they did not, they were told not to enforce it. I believe that's exactly what the plaintiffs did allege. Is that not what they alleged? You know, and again, they're pointing out things like I showed you the document before and the portion. If I note this part to you, there's a police report out there and it states, quote, I reviewed the assistant state attorney's email regarding this matter. It reads that he would caution against enforcing this injunction. I believe the allegation is that Dan Owens said for Levy County Sheriff's Office not to enforce that. I believe that is the allegation. 100%. My God. Levy County judicial records demonstrate to the contrary as cited above. Even if they chose not to act, however, Mr. Owens is not an agent or representative of them or vice versa. Nor did Mr. Owens direct or have authority to direct them. Oh, yeah. You know, he just hits them up and he's like, yo, maybe you shouldn't enforce this. Maybe we should investigate the victims. You don't think that the prosecutor's office has it? Let me tell you something. This is how this works, by the way. I have dealt with a sheriff's office before in looking at protective orders. And guess how they decide whether or not they're going to arrest somebody. They go to the prosecutor, because if the prosecutor will not press charges, they're not going to arrest a person. And prosecutors are absolute scumbags at the best of days in most cases I've found. I do not have a lot of respect for very many of them, in fact. But this went above and beyond. When they're writing and being like, yeah, what do you think law enforcement takes from that, number one? And to write that and to say, hey, why don't you look into it? You don't think they have the authority to tell them? You don't think that the sheriff office is taking instruction from that? That is absurd to say. Mr. Owen is simply not the proper party against whom to bring the claims, because Section 1983 requires personal involvement and constitutional violation. It's like, again, you're suing the wrong guy. Sue the cops. That's exactly what they said. Mr. Owen is simply not the proper party to bring this against. You should sue the sheriff's department. That's exactly what this says. I am very proud of this. That is amazing. Dan, that is absolutely amazing. I am amazed that this is their argument. We're immune. We can do whatever the hell we want, even if it's terrible. Okay. We're not the right party. If you want to sue somebody, you should have sued those guys. They'd be better. But okay. Plaintiff's down state of claim. Again, dismissed without prejudice. The email is not actionable under Section 1983 to the extent plaintiff's claim is premised on legal advice. Mr. Owen purportedly gave the Levy County Sheriff's Office on whether to enforce the protective order. They failed to state a claim because his email contained no legal advice or even a directive. Okay. Well, apparently the police. So you're like, well, you can't prove that I told them not to do that. Like I said, I am under the impression there's more. Is there more, Dan? Did you guys set on something? I think when we start looking into this nest of vipers, that we might find out that there's a little bit more than what we have already. I would not be surprised to find out there is another email, there's another message, and that it is being closely guarded. That is something that we are supposed to be privy to. But you'll notice with body cam and other things as well that, again, things we are supposed to be able to look at and to have access to, we oftentimes are not permitted to. It's wild. It is wild how they play this game, man. While one of the exceptions to absolute immunity involves legal advice provided to police, while one of the exceptions to absolute immunity involved legal advice provided to police. That's not what we did here. Okay. All right. That's a fun little dilly, by the way. Yeah, we have absolute immunity. Well, there are exceptions to that. But no. One of those is providing legal advice. But no. We didn't actually tell them, even though the police officer said, again, how it says, I've reviewed the email. It reads he would caution against enforcing this injunction. No, I didn't actually tell them to do that. That's pretty messed up, isn't it? When the police are saying, yes, you very much did give legal advice. So the police are stating that. Oh, you did. They wrote it in a report. I bet you Williamson, by the way, got the tongue lashing of his life for putting that in a filing. I bet you they went after him, and they went after him hard. I 100% bet you they did. Now in Burns, the Supreme Court determined a prosecutor was not immune where he advised police that hypnosis could be used during suspect questioning. Oh my God. Unlike the prosecutors in Burns, his email gave no advice at all. Okay. It suggests no action. It gives no direction. It clearly requests more information. Really? Like I said, the police, they seem to, again, I'm wondering if there's more email. Dan, are you hiding something? I would love to know. I'd love to know if you guys turned over everything. I really, again, there's some kind of little major malfunction in all of this where they're saying, we never did that. And the police are like, yeah, his email says that. Again, he cautions against enforcement. See, I wonder, like I said, if there's more email. Because, again, it reads that he would caution against enforcing this injunction. I don't think somebody drew inference from something they read. I think that this is something else. I would not be surprised to find out that this is only starting to get interesting. But we'll find out. We'll see how it drills down. Plaintiff fails to allege she gave legal advice, made any other statement outside of the email. You see how, again, one of the things in this game is to set on items. So makes you wonder. Or took any other action to direct law enforcement investigation. Here again is a case talking about finding prosecutors entitled to absolute immunity, where plaintiff failed to plausibly allege that the prosecutor, quote, directed an illegal raid, insisted that officers included fabricated evidence and a warrant affidavit and acted it in their investigative capacities. Given that the prosecution orders were in fact later enforced by LCSO, where the plaintiffs reported violations and charges brought, this inference cannot reasonably or plausibly be made that any such advice was given. Plaintiff failed to state a claim. Again, the police themselves stated, and I like the game where they're talking about, well, we did press charges. Yeah, and then what happens to charges? Like I said, were charges dropped? Do charges get dropped with these people when it comes to anything against them? And I want to direct you to something that Patty actually stated. She stated that when she went over all of this, excuse me, my sinuses are driving me nuts. She stated that when she talked to the prosecutor's offices about, her little run-in with John Cook, that they were more interested in Jeremy Hale. So they were more interested in YouTube and talking about him than they were in actually doing something about things. It makes you wonder, doesn't it? Makes you wonder what kind of game is being played. I'm glad that there is scrutiny on these people, because otherwise I think they had been playing a really jacked up game. I do. And I think that if you don't shine a spotlight on them, that something even worse could happen. So now the court again, no claim, dismissed with. So they failed to state a claim under 18 U.S.C. 2265. So the plaintiff's protection order states that it must be given full faith and credit pursuant to Violence Against Women Act 18 U.S.C. 2265. Under that, any protective order issued that is consistent with subsection B of a section by the court in one state shall be accorded full faith and credit by the court of another state and enforced by court and law enforcement. Now, Mr. Owens is neither the court nor law. That is jacked up. Do you see this claim here? Well, you know what? I don't actually have to do anything with a protective order. That is messed up. That is beyond messed up. He's saying, I'm not law enforcement. I'm not the court. Therefore, I'm under no obligation to give full faith and credit to protective orders. You have got to be kidding me, man. Because with a protective order, the only way you get enforcement with a protective order, the only way is for a prosecutor to stand the buck up and say, yeah, we will, because law enforcement will contact them. This is absurd to argue this. I'm not the court. I'm not law enforcement. I don't have to give a fuck. What are you kidding me, man? This again, there should be, when he runs for office, I would love for any of these people, when they run for office, I would love for the public to see some statements like this. Hey, you come from another state and you have a protective order because someone's stalking you. Well, guess what prosecutors think? They're not actually law enforcement. They're not actually the court, so they don't have to care. They're under no obligation to give full faith and credit to the protective order. That is mind-boggling to write down. Further, under 18 U.S.C. 2265B, only protective orders issued by a court that has jurisdiction over the parties and matter under the law of such state, and reasonable notice and opportunity to be heard is given to the person against whom the order is sought or entitled to full faith and credit. The Florida Enforcement of Foreign Judgments Act must also be considered. A foreign order may be challenged for lack of jurisdiction or extrinsic fraud. What the fuck? Oh my God. Mr. Owens questioning, therefore, look what they're trying to play here. They're like, well, we actually are entitled to look into this to see if there's fraud. Are you kidding me? He's under, this is scumbaggery at its best. The admissions that they are saying here should be reputationally disastrous for Dan Owen. Because what they are admitting here, this is how they see protective orders. Can we investigate the person that has a protective order? Absolutely. If we want to put the person that has been victimized in jail, we are 100% able to go after the victims in it. Should we also, while there, should we give full faith and authority to something outside of our state? Well, only the cops and only the judges, they have to do it. We don't have to give a damn about you. Wow. What a statement, man. This is insanity. Holy God. This is the kind of stuff right here. Again, I don't give a damn what happens with just this. I think this is broader. I think this has become much bigger when this is the mindset that state prosecutors have. I think this right here should be sent to every media outlet and noted. This is what Florida prosecutors, this is why Levy County has such an abominable prosecution rate. Again, they have allowed people to plead out of things where you have overwhelming evidence of crime, where you have a crime, let's say of a SA, where they have, again, horrible crimes. They let people plead out, and when they do, they're not even registered as offenders. That's the kind of wonder you get from them. You wonder, hey, again, there have been U.S.-wide articles. We have had documentaries written about how abominable these places are. They need to be held under a microscope, like the ants they are, because they think that they operate outside of the law. They think that they can just bend and flex the law in any way they want. And this right here, this is offensive for anyone that has ever been the victim of something, or has a family member that has been victimized, or has known somebody. This is offensive, because what this says is that when I cross this imaginary border here, sure, you know what? I can get in trouble for robbing banks. I can get in trouble for all kinds of crimes. But you know what? Stalking them more as the victim, I might actually be the one investigated. And they may treat me like absolute garbage. And, well, the prosecutors have every right to do that. Oh, wow. Wow. No liberty or property interest in protective orders. Plaintiff fails to establish a deprivation of liberty interest protected by the Due Process Clause. The 14th Amendment states that the state provides that the state government may not deprive any person of life, liberty, or property without due process of law. To establish a procedural due process claim, a plaintiff must first show deprivation of liberty interest protected by Due Process Clause. Quote, the Supreme Court has considered whether a party may assert a claim deprivation of procedural due process based upon the state's failure to protect liberty or property interests. Citing again through here, another and the court held no such interest existed. A benefit is not protected entitlement if government officials may grant or deny it at their discretion. As the 11th Circuit explained, the Supreme Court of Florida has held, quote, there is not now, nor there has ever been, any common law duty for a governmental entity to enforce the law for the benefit of an individual or specific group of individuals. Huh. That really reads terrible. That reads terrible. You know what that says? God, wow. Just read that and think individual or group of individuals, and just think about what that could be used to excuse. Okay, because plaintiffs do not have a constitutionally protected property or liberty interest at stake, they fail to state a claim under. Again, they always try to strike down 42 USC 1983. That of course that is typical, but the way that they do this is terrible argument. Again, terrible argument. They don't care if they look like scumbags. Again, this just looks terrible. Plaintiffs fail to establish causation. Plaintiff's lawsuit fails because none of the alleged harm can reasonably or logically be connected to Mr. Owen's conduct. Quote, a 1983 claim requires proof of affirmative causal connection between the defendant's actions or omissions and the alleged constitutional deprivation. Another quote, the overarching rule is that where deliberative, autonomous decision-making stands between a defendant's actions and the plaintiff's injury, the defendant's action cannot be the cause of plaintiff's injury under 1983. Now, plaintiff's count 1 states, as a direct and proximate result of defendant's failure to enforce protective orders, plaintiff suffered continuous harm to each plaintiff/victim's sense of safety and well-being as a direct result of defendant's failure to enforce the protective orders, including without limitation 1, physical harm and the threat of such harm, 2, emotional and psychological harm as a result of Preston and Cook's intimidating, threatening behavior, assault with a pew-pew, for example, causing mental distress to the plaintiffs, fear of death or bodily injury due to Preston and Cook's persistent and obsessive behavior. By the way, if somebody would, I want to ask you to do something. Do me a favor. When you go through, I'm coming back to this spot, okay? But I'm going to ask for a favor off of this. Give me one thing. Give me 1 second. I want to roll back to something. All right. I'd like something pulled up so when we could discuss this, okay? I would love for somebody to go and to pull the information on, you can just screenshot this part right here, all right, where they're talking about the cases that they brought, because I would be, I would like a very complete picture showcased to people that are looking at this, saying, yeah, okay, what happened to those cases? What exactly happened? Did we ever go before anything? Did we ever actually have any type of a trial? Did we even have prosecutors willing to look at and do something about this? And again, as it says, it emboldens these people, and it does. You think about it. If there is no threat under law, what do you think the message is there? What is the point in a protective order if there is no enforcement behind it? When we're looking at this stuff, you see that, again, they fear it impacts their lives and safety. It has financial harm as a result of them being emboldened. And absolutely it would embolden. Now, further, they go on to further allege Preston and Cook enlisted others in a civil conspiracy to harm Hales as a result of Preston and Cook being emboldened by the defendant. Yes. And they do nothing about this stuff. They were even contacted by these nut jobs. Their offices, they even talk about this in their communications, their internal communications to talk about these idiots. They're not like, maybe there is a problem here. Nope, none at all. Now, again, they say, well, they did not allege any connection to the non-parties for Mr. Owen. Non-parties were aware of Mr. Owen's investigation of the protective orders or any other circumstances that might link Mr. Owen's email to harm alleged. The plaintiff's damages were obviously the result of third-party decisions. So look, I like this. This sounds like an admission of damages. Wow. You know what I love there? I love that they didn't say plaintiff's alleged damages. They say, well, the damages that he faced, that it's just not Dan's fault. If you're going to blame somebody, blame LCSO, blame Preston and Cook, blame all these weirdo third parties, but don't blame them. But it's amazing. They didn't call it alleged damages. They said, okay, you got damages. Well, that's somebody else's problem. I didn't do it. That's interesting, isn't it? Usually you take the stance that they're alleged damages, but okay, I like that. I like that they kind of admit to it. I didn't do that. I didn't cause it. So accordingly, he's not liable for LCSO's decision not to act on. Again, he's like, it is, when you go with third parties, it's the sheriff's office fault. I hope the sheriff's office sees this. Boy, this has got to feel good. This is what they think about you. No failure to protect due process cause of action. Plaintiff claims Mr. Owens failed to enforce the protective order to deprive them of protected liberty interest without constitutionally adequate process. As a starting matter, nothing in the language of the due process clause itself requires the state to protect life, liberty, and property of its citizens against invasion by private actors, such as Preston or Cook. Well, that's lovely to hear, too. As a starting matter, nothing in the language of the due process clause itself requires the state, the people that they're supposed to protect you. Well, nothing in that actually requires them to protect that against private actors. Nor does the history supporting such an expansive reading of the constitutional text. Finding, again, here's another finding, sheriff's office did not violate due process by failing to arrest a restrained party. Let's see. Although decisions of other district courts are not binding, they may be cited as persuasive authority. Quote, although a district court would not be bound to follow any other district court's determination, the decision would have significant persuasive effect. So even though we're going out of district, okay, that's an interesting way to play that too. Plaintiff's claim fails because Mr. Owen was not required to protect plaintiffs from the vaguely alleged private action, actor conduct by Preston and Cook. Wait, what? He wasn't vaguely alleged? I think I think that we have had it very well defined what action has been, what conduct has been there. It's not vaguely alleged. What jackassery, man. Further, American jurisprudence, a private citizen lacks a judicially permissible interest in the prosecution or non-prosecution of another. Mr. Owens is not liable for failing to prosecute. The only two circumstances that the government's failure to protect might constitute a violation of the due process clause are if failure was arbitrary, conscience shocking in the constitutional sense, or if the plaintiff possesses a property interest in enforcement of restraining order. Here's the case explaining that federal constitutional standard, but concluding that Colorado law did not create a property interest in the enforcement of plaintiff's restraining order. Florida law does not create property interest in enforcement of restraining order because Florida restraining order statute gives prosecutors discretion to prosecute the violation. Yeah, you know, the problem again with the allegation isn't that he didn't just prosecute, it's that he stepped outside of his of 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 his office, and he told others in acting on this, he told others not to prosecute, which is in of itself a pretty wild thing when you think about it. This stuff is just wild to look at, period. It's all absolute insanity. It blows my mind, man. It absolutely blows my mind. I swear. I laugh because of the sheer insanity of again what they will admit. It's what they think of citizenry. I mean, when you and I have a problem, we are forced to rely on these people. We are. We can't go out and we can't do anything about this. If Hales would have gone out and tried to act on some of this stuff himself, what do you think would happen to him? We know exactly what would happen. You know, I mean, apparently, apparently nobody's to blame. Or others are to blame, depending on how you read it. Others are to blame for the way that they look at what Dan Owen says. Because, you know, Dan Owen didn't actually mean this. He meant something else, and he's allowed to investigate the victims. It just blows my mind. Now, they say here, you know, again, we have the argument about property interest. We also have, nor was Mr. Owen's conduct arbitrary and conscience shocking. The shock of conscience test is to be narrowly interpreted and applied. Yes, you know, we must very much defend the people that that we give. You realize what would happen to it. You know what's amazing to me is there were so many ways in mental health that you could be sued. There were so many laws governing your behavior in it. There wasn't some narrowly applied standard. It amazes me. If I would have written somebody and tried to do some insane thing, I would have been in all kind of trouble. Here, though, they're like, yeah, even though it is your job, you know, you can decide how to apply that job. That's just an insane argument. But the Supreme Court, again, said that it repeatedly emphasized that only the most egregious official conduct can be said to portray in the constitutional sense. Here, reiterated the conduct that shocked the conscience was so brutal and offensive that it did not comport with the traditional ideas of fair play and decency. It would violate substantive due process. And so-called substantive due process prevents the government from engaging in conduct that shocks the conscience or interferes with the rights implicit in conduct ordered liberally. Historically, again, this guarantee of due process has been applied to deliberate decisions of government officials to deprive a person of life, liberty, or property. Now, the only conduct alleged here is that Mr. Owens sent an email to the sheriff's office that showed that he was investigating the Ohio court's jurisdiction over the restraining orders. The email investigation cannot be a shock to the conscience. Cannot shock the conscience. Yeah, you know, you can't be shocked that he would invest. You know, that's not bad enough. It's not bad enough. You can't hold him liable. Oh, Lord. Nor does the plaintiff allege that he deliberately acted to deprive the plaintiffs of due process. Plaintiff's claims are wholly devoid of factual and legal basis. The complaint does not contain sufficient matter to state a claim for relief that is plausible on its face. Court, again, should dismiss with prejudice. No jurisdiction to grant injunctive relief for unrelated protective orders by unknown parties. So plaintiff purports to seek injunctive relief for other entirely unrelated protective orders from unknown states, protecting unknown parties from unknown restrained parties. Federal jurisdiction is limited to actual cases or controversies under Article 3 of the United States Constitution. To establish a case or controversy, a plaintiff must have standing to bring a claim. A plaintiff must show standing for each claim he seeks to press and for each form of relief. A plaintiff's demanding declaratory or injunctive relief must show a real and immediate threat to future injury and a sufficient likelihood that he will be affected by the alleged unlawful conduct in the future. Yeah, I wonder if he could be affected by that at all. Wonder, hey, we have a protective order here. We won't act on it. Could you be hurt? Serious? Is he at risk of continuing or future harm? Let me think about that. Let me think. If somebody causes me not to be able to have my protective order in which somebody pulled pew on me, could I potentially be harmed now or in the future by that? I'm going to say yes. I'm going to say that puts me at serious risk. Again, I think they're playing around it, and I very much wonder if there are other communications that we have not been allowed to see yet. I very much, because the interpretation makes me, I wonder if they can motivate the Levy County Sheriff's Department. I wonder if they have had some pretty stern, I'm going to say, calls as well. That's one thing that I think we need to take under advisement too as citizens. I don't think that any, like when they have communication, a lot of times to step around your ability to find out what's stated, they will not email one another. They will do jacked up things, and they will do it via phone. Just so they, when they're depriving you of your rights, when they're doing something messed up, they don't leave a paper trail. That's it. That's really instead of fixing problems, that's oftentimes the lesson that people like this would take from something. Don't leave a paper trail. But plaintiff's request or relief amounts to a request that the court require Mr. Owen to follow the law. An injunction requiring a party to obey the law. The obey the law injunction is unenforceable. Oh my God. Isn't that amazing too? You can't ask me to obey the law. What now? We're prosecutors. We're immune from the law. I love it. Again, I understand what he's doing. It reads so poorly. I hope everybody and their mama gets to read this kind of stuff. They should just read the arguments. Have someone sit down and explain it to you and why this shouldn't offend your sensibilities. I would love that. I would love for the state to sit down and explain to people that, again, if you're stopped, why shouldn't this offend every sensibility you have? Now, qualified immunity. Here's the qualified immunity shield. This will be fun. Even if plaintiff could state a cause of action for the conduct they alleged, Mr. Owens is at the very least entitled to qualified immunity. Quote, government officials performing discretionary functions generally are shielded from liability from civil damages insofar as their conduct does not violate clearly established statutory constitutional rights of which a reasonable person would have known. Plaintiffs bear the burden of showing that, quote, legal norms allegedly violated by the defendant were clearly established at the time of the challenged actions, or the law clearly described the actions the defendant took. Now, to satisfy this burden requires more than making general allegations of constitutional violation or by stating broad legal truisms. As the 11th Circuit has repeatedly stated, plaintiff must prove the existence of, quote, a clear, factually defined, well-recognized right of which a reasonable officer should have known. Now, again, this is something that you and I are not protected by. Have you ever heard of not knowing or understanding the law? That is not a defense for violating the law. You and I can be arrested for that, but this is a defense that police officers, you hear a lot from them. Well, I didn't know. I didn't know. You have to think about how insane that is, you know. Ugh. You do. You have to think about that. Because it not only has to be well recognized, factually divine, but they a reasonable person interpreting all of this, they have to 100% know. Again, you and I would be arrested by the very claims that they are allowed to make. And police make this all the time. When they make the argument of qualified immunity, when actors that, again, are in our employ and they act against the very people that employ them, the argument is oftentimes, I didn't know that was a problem. That's part of qualified immunity. If you break it down, it's basics. Our case establishes that the official is alleged to have violated must clearly established and more particularized and hence more relevant sense. The contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. Again, they have to be able to understand that. Oh my God. It's so ridiculous when you think about it. Because listen to this. Qualified immunity defense provides ample protections to all but the plainly incompetent or those who knowingly violate the law. This is their defense. Again, I didn't know that this would be a problem. I didn't know that telling Levy County not to enforce a protective order could be a problem. Good argument. I like that. A right is clearly established at the U.S. Supreme Court or the 11th Circuit. Precedent on poor, there is not. And federal and state laws all indicate the action Mr. Owen took were reasonable and expected. It's expected that you investigate the people that have protective orders. Oh, man. So anybody, I would be curious about this. I would love for Dan Owen to show me other examples of where he investigated other people from other states that were victims. I would love to see how he's investigated all of them to prove that when they said that they resided in a certain place, they absolutely did. That's wild. I would love for him to show me where this is typical behavior for them. Because if it is, that's its own problem too, right? And if it isn't, that's a problem as well, right? But hey, but it's not unreasonable for Mr. Owens to believe he could assess out-of-state protective orders for issues under Article 4 of the U.S. Constitution, 28 U.N.C. 1738. Assess the Ohio court's personal jurisdiction over Florida residents. This was not in question right here. This is not. He was not looking at the Ohio court's personal jurisdiction over Florida residents. Absolutely not. What jackassery again. And assess the orders for extrinsic fraud under the Florida Enforcement of Foreign Act. He is entitled to qualified immunity for the investigation. The court should dismiss. This is, again, you know what? When the ecosystem looks over this too, what they won't understand is something like this could happen to them. And when it does, you remember what they say about what should or shouldn't qualify. Because one of them, when they step into a BI, but remember, a lot of them are actually, they're more in the perpetrator categories of crime. So of course, they don't want anybody ever looking into to protections. They love the idea that, hey, if somebody was victimized, nobody would look into it. You think about that. The dismissal should be with prejudice. Now, plaintiff's complaint lacks arguable merit in law. In fact, of course, they're going to argue that this should be dismissed again with prejudice. That means you can't refile. Although Rule 15A typically permits amendment once as a matter of course. It doesn't require the court to allow amendment when the suit is frivolous. Even were plaintiffs proceeding pro se and the court required to construe plaintiff's claims liberally. The court would still be warranted in dismissing with prejudice if amendment would be futile, because amendment is quote unquote unnecessary if the claim is patently frivolous. Plaintiffs here, though, represented by counsel, court should hold plaintiffs to the strict pleading standards and blah, blah, blah. They're saying you shouldn't even be allowed to go in and, we understand that you're allowed to amend complaints and to come after it, but you should just dismiss this outright, spit in their face, because, we're the state. Because we're the state. So in conclusion, plaintiff's claim fails because, one, Mr. Owen is absolutely immune. He's absolutely immune to these things. I mean, doesn't matter what he does. I love qualified immunity arguments because they're so offensive. They are. I absolutely love them. I love it when people see qualified immunity argued. Because you've got to understand that when that police officer beats the crap out of somebody, or, and you're like, how did they get away with that? Well, that's because they are given qualified immunity. You always hear it spun the other way. You always hear it spun, well, these folks, in order to do their job, they need to have all these protections. Well, unfortunately, when they're not doing their jobs, they also have these protections. And you have to clear. That's why I was saying with this, you have a lot of hurdles to clear when going forward. But I love the idea that state actors are called out in these kind of cases. I absolutely love it. I love just the sheer audacity of them thinking they can do anything and somebody being like, you know what? I'm not going to let you do that to me. I kind of love it. I do. I absolutely love it. So they want it again dismissed because they say it fails to state a claim, and he's got qualified immunity. So of course they're going to call him frivolous, unreasonable, without foundation, constitute abuse of judicial process. This is a typical argument. This is very typical. But I thought you would enjoy this argument today. Because again, what it says is we can do whatever the hell we want. And what does it matter if you say X, Y, or Z? I kind of love the argument. I love the audacity to it. I love the fact that when they're cornered, they say, you know what? Why didn't you sue the sheriff's department? You should sue them, not us. Not Dan. Not Dan. He's not the bad guy. Again, the thing that really sticks out to me in all of this, though, I mean, when we get down to it, it isn't just this matter of stupidity. It's the fact that, again, when you look at it and you look not just at the letter, but you look at some of the crazy, man, whoops, I didn't mean to pull that one up, although that one is fun. When you look at the police incident, though, when you read through it, you really, again, you got to think. It said, police, they stated that they reviewed the assistant state attorney's email regarding this matter. Now, when you read that, like I said, I think there's another email. Because when you read this, I don't think it's referring to that email. I think there is another email. I absolutely do. I do not think that police would look at what was stated in that one email and say, hey, that email by itself, you would draw this conclusion. I think there's something else. I think it's being withheld, and it's going to be really interesting to see the links to which we have, them potentially trying to conceal it. We'll see, though. Like I said, we will see. But this is a crazy game they play. Anytime they're cornered, I do like I said, that Hales is calling them out, though. Because ultimately, when you have prosecutors out there that are telling you, again, we have every right to decide. They run on being the voice to the voiceless. You are not allowed. And any other thing, you could go out, you can essentially you can sue, you can protect yourself. What can you really do when insane people do insane things to you? You have to rely on the police. You have to rely on prosecutors, and you have to rely on judges. You need all of that working smoothly. And if they decide that they are not going to give a damn about you, then you run into real problems. And I mean, just as is, prosecutors are bad enough because, again, their egos. I told you all what happened with a prosecutor here. I mean, we had a prosecutor, like, really think about this. We had a prosecutor go to another county, so they don't have any jurisdiction there. They ended up actually getting replaced by this. I've never seen a prosecutor replaced, right? But we had a local, now this is a district attorney, okay, but still they're prosecutors, right? But the DA here, he would run around like he thought he was Wyatt freaking Earp. He would run around with the old school badge on his belt. He would showcase how he was strapped, and he's the law. He went to another county. Now, he tried to claim that he was doing a ride-along, but he was in his own vehicle. There was no one else in the vehicle, and he was captured on camera. There was a dangerous suspect. Now, granted, I will grant this. There was a dangerous suspect. They had law enforcement in that county trying to corner them. They were in a residential area, and these people were driving, and they were driving erratically, dangerously. They were trying to do harm to people. But this guy, a prosecutor, jumps out of his car. He brandishes his firearm and just starts firing in a residential area in a county that, again, he has no jurisdiction in whatsoever. He has gone into this county for God knows what. His rounds end up going through different people's walls. And one of the rooms that a round goes through belonged to a child that luckily was not home, but it could have well ended in something terrible. Now, with that, it's gone to the point that they had an emergency meeting in the state with our state reps and whoever else is involved in that, and they replaced him finally here. It's crazy news, and it's something, again, I would cover by itself as a story, but I know that they would retaliate so badly here that it is not in my interest to cover that story because, again, they would make my life hell for it. But that tells you what prosecutors do, and that's just typical with their mentality. You have so many of them. Now, I'm not saying every prosecutor's like that, but a lot of them are. A lot of them, especially these small town folks where they think they can do absolutely anything. And this reads like the same people that think that, it does. It reads like, hey, I can do whatever I want. I am, again, immune, all but for the worst of the worst. And that's what they all believe. When it comes time to pay the tab, when it's due. But I really would like, I would really like to hear from this person. I bet you Williamson has had conversations with the prosecutors about that. I bet he took one heck of a tongue lashing. And I actually wonder if he would tell the truth if he was on the stand of what he read. I do at this case. Like I said, I think that there's probably something else out there that we do not know about yet. You've seen withholdings before by state actors where they've tried to pretend that something doesn't exist. They'll do anything to pretend there's reasons they don't have to turn it over. I don't have to turn it over if it's involved in something that's active or this or that. I'd be curious, again, if they have turned over everything for FOIA, because there are FOIA, they will try to avoid FOIA too. So we'll see. Like I said, it'll be an interesting battle. It'll especially be an interesting battle because you're not dealing with private actors here. You are dealing with our tax dollars being utilized as a bludgeon, and they have limitless defenses under that. So it'll be interesting, like I said. Anyway, Let's look at some super chats now. What wild stuff. Max Lab. No, seeing that Dan Owens doc is crazy and stupid. It is, man. It is. Like I said, thanks to Max Lab, by the way. I appreciate you. Again, I was out kiddos today, and I wouldn't have seen this come in when it was. So Max Lab, again, everybody give Max Lab props. You know, he has been very diligent and making certain that people that they see what's going on with, there's so many cases here too. If it weren't for a lot of you folks, this would be nearly impossible to keep up with, because there's just so much that goes on. It's not just cases, it's all the actors and more. So like I said, I appreciate you folks. And again, Max Lab has a channel. Go subscribe to it. And also, if you want to pick up documents, he's been uploading them. You can go, you can see them, you can easily screenshot. I mean, it's a lot. It's an easy method for you to obtain things, because not all of these are free. So it makes them hard to pick up. A lot of them, again, they come with costs. So thanks, and supporting that too will help with costs associated. If you get monetized, that would definitely help out with things too. Travis, thanks for the 2. I read this before, but man, I know you've been having a rough go. I want nothing for the best for you, bud. I'm glad that I've been able to come on today too. And I'm glad we can be entertaining and take away at least a little thought on that, man. It's craziness, So thanks for the vibe. For the lurkers. Lurkers' lives matter. I know, man. I know. Who represents the lurkers? Oh man. You're like, I represent the lurkers. It's good to know. It's good to know there's someone out there that will speak up for the lurkers at large. Thank you there, though. I appreciate it. All you lurkers out there, too. I see you. I appreciate you. Without you, fun times. Hey, will somebody link Max Lab's channel, by the way? Somebody was asking, I saw that, hey, where's his channel? If somebody would link it, I'd appreciate that. What's up, Maestro? Like I said, I liked that there with your name. I enjoyed it. Thanks for the 2. Here's some sweet and sour breadstick money. Sweet and sour breadsticks. That's what a taste, man. What a taste. Sweet and sour breadsticks. That just sounds horrible when I think about it. Mama Bear, thanks for the vibe. Just listening tonight. Keep up the good work. Thank you. I'm much appreciate that. I appreciate you being here, and I appreciate you tuning in and looking at the craziness too. Fallen Hero, man, as always, brother. Appreciate you. Good to see you there. Here is Max Labs, by the way. Somebody said they couldn't find it. I see the posting there by Kitty Ninja. Thank you. I'm going to pin at the top. That way you can find Max Lab real quick if you want to check that out. Subscribe to him. Again, appreciate his efforts. He's been doing a lot. Like I said, a lot of times that with all you folks that send things and stuff, it is very appreciated, because again, I could not keep up. There's so much insanity that goes on. I just can't keep up. So thank you all. Thank you, Fallen Hero, for being here all the time, my friend. Appreciate you. And thank you for the gift as well. What's up, Lurker Tex? Stein, I'm wondering, like, what? See, you know why they put the ats here, by the way? You know why that is? So I'm going to explain this too. So people have been asking about why your ats are up here for your names instead of names. It was put in because, have you seen all of the fake accounts that are pretending to be folks? Like myself, for example. It's got so bad in comments, you would have people pretending, like in my own comments, I will find 100 fake gun umbrella guys. I'll ban different ones. I'll ban different spellings of my, of certain things. And it gets to the point where you think you'd be able to deal with it, but you can't. So what they've done is they've taken the @ and they showcase it. That way you're not seeing like people creating that umbrella guy at some, creative interpretation. They can only go so many ways with that ad. So it is inconvenient in some ways, but the platforms are so desperate to counter fraud that they're having to resort to this stuff. And you ban links. Even here, it's crazy because I banned links. I had to go to this point. I had banned links except when mods put them up. And I had to do that because you would have so many fake links, fake scammy items that would be put up, and it didn't work. Like all these things people do, and you would have people that they will get scammed, and hopefully this helps. But it'll be something that people will have to, like for your @ you can change your @ too. So where it has on your account, you can change the @ whatever. You can change it to your name or a very close interpretation of it, just know. So if you don't like the way that it's come across, most people, when that came up, if you want something different, you can go in and you can correct it. And the one good thing about correcting it, when people, I'll ask people to, like, if you have a problem, to send me your link, your YouTube account. Well, that's because, like, say the account right here, if it had a name like, I don't know, I'm just going to say Effenstein. Let's just say it was Frankenstein. And just it's not, but if it did, I would never be able to figure out what the @ here is. You know what I mean? So, yeah, people can make their accounts more easy to find. That way, if there's ever a problem too. I mean, it can be. And thank you for the lurker tax, by the way. The only thing is, like, again, if some people I know, like who you are, and it drives me nuts because if anybody has a picture that could be even somewhat like yours, it does mess me up here. All right. Mama Cat dropped 5 giftos. Thank you. Thank you for listening to my meandering about on that subject too. Thank you though for the 5 gifted memberships there. Thank you. I appreciate that. Mama Cat too, and a lot of people appreciate those too. A lot of people will write and say thank you. It makes me feel part of it. So when people drop gifted memberships, folks, that's amazing. Laura dropped a gifted membership as well. Thank you, Laura. Appreciate that. Again, like I said, it helps out the channel, which is amazing, and it also says hey to other people. You're part of something too. So thank you for that as well. Tizzy, what's up, Tizzy the Bounce? Thank you for the breadstick money. Hey, Doug, you are the best ever. Well, thank you for that. You know what, Tizzy, you do a damn good job too. I have enjoyed your videos very much so. I'm proud that you have gotten. When I looked at those, one of the things that I really like is that you're so detailed. And the humor part, it makes the presentation so good. I think I like almost the matter of fact. Sometimes some of the stuff comes off as dry, matter of fact, like humor. And I love that kind of humor. So that always cracks me up. Emma, thank you for the 2 there. Appreciate that. Lurker saying amazing coverage. The best ever. Yeah, baby. Thank you. I appreciate that. Yeah, it's been something to watch, something to behold. I want to see, again, if this case, how it's going to proceed. First, I want to see how it proceeds. But if it also gets hit, it gets knocked down. I'm to the point anytime I see law enforcement or officers of the court. I haven't seen a lot of prosecutors taking the task, but I've seen a lot of, like, with police. I've come to expect those lawsuits to fail in their initial stage, because You know, you're essentially, you're asking these authorities to to pretty much police themselves. And a lot of times these actors, they know each other. You know, you think about this. Hey, I want you, this old boys club, I want you to not only police each other, but you know, the protections this person enjoys, well, they're also protections that they also enjoy. You know, the judges and more, they enjoy those too. So it is interesting, like I said, when you see them taken to task. And then you have appeals courts oftentimes that step in and step it up. So thank you, Emma. Kate, what's up? Hey, home from the hospital. I hope you're doing okay. I hope I'm curious how you're doing, like when you're home. It's a good feeling to be back in your own environment. Prayers to you, man. Love to you. You know, show up. And you know, here's one of the wonderful things with live stream. One of the reasons I like to be live every single day is because it helps to distract the mind. There are so many of us, and that's myself included too. You know, there's so many of us doing so many things, getting over things, having things happen, that it is a welcome distraction. So come hang out. Appreciate you. I hope you're doing great there or recovering. However, I hope it's better. Like when you get out of the hospital, it always feels better. So that, and again, love to you. Mama Lori, thanks for the year too. Oh yeah, and by the way, thank for the year there as well. Thank you also, Mama Lori, for the year here. Didn't LMNOP tell the grudge judge that Jeremy Hales committed perjury? I seem to recall something like that. Can his communication be requested? Did LMNOP tell the grudge judge? Yes. she alleged all kinds of things with Hales. There were 3 meetings, in fact. Well, I mean, there was a lot, first of all, a lot of things that happened in court. But outside of that, there were the 3 ex parte hearings. There was a lot of that was crazy. Now, with communications being requested, all communications can be requested through FOIA. There are, however, ways that they try to work around that. First of all, you have to think that state actors, number one, are being truthful. You know, they're not trying to work around and be wormy about something. They're not trying to conceal something. And on top of that, you also have different ways. Again, they can claim things like there's an active investigation, there's this or there's that. There's a few. I'm not. That's just one instance. But there are things where they can claim that we're not going to turn it over because, and that gives them some protection or leeway. Now, a court can tell them that they have to turn over something, and again, you know, there's a level in there where honesty from the systems that we're supposed to have in play, they're supposed to make a lot of this recoverable. But you know, one of the ways that these folks work around these is a lot of times, just like 2L said, I think 2L notes the game that a lot of these idiots play. Instead of going in and being lawful, doing things that you're supposed to, they will instead have phone communications instead of written communications, because with phone communications, there's no record of the terrible things that they try to put in play. Isn't that awful, by the way? You have to wonder whether your employees, the people who have been voted in, are trying to conceal something, and to what level they're concealing. It's just nuts, isn't it? Thank you. What's up, Kim? Thanks for the fun there. They dismissed Patty's case against JC due to their biased view of Jeremy. Yes, they made it clear. They made her travel, yeah, and dismiss. Yes, they made it clear. And you know, here's the question. I hope Dan Owen can answer this. Are you claiming that your Your folks, again, they don't care though. First of all, they're saying, oh, we're not entitled to do X, Y, or Z. We're not entitled to have to go out and prove that not only did that we knowingly went out and violated something, we had to know that it was a violation of law. Again, imagine that. Imagine being able to say that. But yeah, they did. They absolutely did that. And there's a lot more to that too. Dan, I'm curious. I would love for them to speak on that. We have communications as well. We have a whole bunch of FOIA requested information that came from those offices. And some of it, again, that's one thing that we need to do a deeper dive through. I pulled it up today. I put it in my has to be done box. So no matter what comes up, because we talked about it and then everything just, it's continued to be insane. But we do need to showcase all of that FOIA information. There's some things in there that are not pertinent. And what I mean by that is they even mixed in a few cases that had nothing to do with Hales, even though it was supposed to be about communication with Hales. I sometimes think they try to muddy the waters that way. They try to confuse you. They also they do document dumps. When you request something, they'll turn over hundreds of pages. They do that, first of all, to bury you in documents, but also to bury you in cost. Oh, we're turning over a bunch of stuff. Well, can you afford justice? It's wild when you think about it, because you have to be able to, like with Hales, one of the things that he can do, like he doesn't have a limitless amounts of money either. He has been able to go out and to fight for his rights and to be very vocal, but it has cost him a fortune. So I hope in this fight too, people have definitely been supportive of them, because I know, one of the things that they have on their side is that they'll be galvanized in their support and they'll say, oh man, I'm going to support this to the bitter end. But man, a lot of people think like a court case will be resolved in a few months, and that's not the case. Like this stuff too, when you have state actors that they won't enforce them. They just told us that we don't have to enforce anything either. When they have that mentality, you can think about how insane this stuff gets. And when you're wondering, how do all these third parties come in and all of this stuff happen? Well, again, they're emboldened by people like Dan Owen, who are just flagrantly saying, I'm under no obligation to protect victims, even though that is what his office is. Oh, crazy. Thanks for 3 months there. Wasn't it Mr. Owen that dropped the case against John Cook? Yes. Yes, indeed. That's the thing. When they talk about, well, we brought the case. Well, yeah. Did you prosecute it? Did you prosecute a case? What a bunch of jackasses. And they have dropped things, again, like the Patty situation, for example. They have a guy that lies to law enforcement about pulling out of the pew and pointing it at a car. Now, he says he never pointed it, but he lied. He says, I didn't brandish one. Well, we know he lied. They concealed the weapon. You have him narked out. Everything's there. And they decide that they're not going to prosecute. Now, why wouldn't you prosecute that? That is an easy win. Why wouldn't they prosecute that? There was a child involved. Why wouldn't they prosecute that? And I think there's an easy answer there. It's to the point that they wouldn't prosecute something that when you look at it and you describe it, when I say somebody pulls a pew on a car with a woman and a child in it, that looks pretty awful, right? You would think most places they wouldn't risk the negative PR. Oh, but Dan doesn't care. Why not? That's a good question, isn't it? Again, thanks for the 5. With absolute power comes absolute corruption. Yes, that is 100%. That's why I always liked, The Watchmen. I always liked the statement, who watches the watchman? Because with that, you know, it's a question about corruption. You know, who does? Who keeps these people in check? Because even the governing bodies that are supposed to keep them in check, they're more worried about protecting their interests. Their interests are keeping qualified immunity at the level that it is to. You know, when you want to strike this stuff down, you ever wonder why courts they seem to operate against what would be I guess a common sense approach to policing this. In fact, that's one of the things that bothers me that I've heard from one political, I think pulpit that I'm willing to pull up is I will hear them talk about strengthening qualified immunity for police, for example. Oh, it's a terrible job. And and I'm like, man, qualified immunity is an overreach as is. We don't need anymore. Denise, thanks for the 10. So what happened with Owen's investigation? Did he follow up? Was not Hale's business harmed? Yeah, first of all, they didn't go forward with any of this. In fact, anything that has come up with Hales where they talk about, well, we've decided to like allow an arrest. Yeah, and then what happens to these arrests? Well, they get dropped. It's pretty crazy. So we press charges, yes, and then you drop charges. You don't allow due process. You don't allow this to go before jury or anything. They don't allow it to get to that point. And you really have to question. But again, their argument is we don't have to. We don't have to. That's just a wild argument. And was Hale's business? Absolutely. And they're, with this, their argument is, so what? We don't have to care. We don't. And it's an amazing argument. That's the same argument. You realize, like something people don't realize with police. This is not the same thing, but you realize that police are not obligated to protect you. In fact, there's a Supreme Court case. This is a horrific case to look into as well. There was a woman that was on the phone, and there was someone beating on her door. It was an older lady, right? Someone's beating on her door, trying to get in and harm her. She calls the police. She's begging for help, and there's no one to dispatch. They don't seem to prioritize this. I mean, this is a person that, again, they're going to be harmed, and you can hear imminent threat. But they're like, oh, we don't have anybody to send. So they stay on the phone for quite a long time. You hear they in fact, the dispatcher tells this person on the phone to ask them to go away. And yeah, they don't. So they stay on the phone and they listen to a very brutal crime happen wherein somebody ends up losing their life. And in that, the family, of course, when they hear this, they are so horrified by what they hear that they sue, and it goes all the way to the Supreme Court. And the Supreme Court, in its answer, they tell us, we the people, just point blank, that it is not the police that are there to protect us. They're there for mop-up duty, after the fact. So it's a pretty horrible thing to think. There are very limited ways that you can hold the police and prosecutors and more. You can hold them liable. Now, one of the things with what we talked about here, like since we're on this subject, one of the things that you can note with this, and I think it is a very important thing to note, is in a protective order. Protective orders, I mean, their specificity. It's very, very specific. So it's easily proven too. Very easily proven. I mean, the fact is, in In a protective order, it boils down to feet. If you can prove that somebody violates that, then you're supposed to be given full faith and credit in Florida to that out-of-state protective order. And again, it's easily documented. It's easily to tell whether that occurred or not. They are 100% supposed to enforce that. And they play, again, Dan Owens, the argument that, well, it's actually law enforcement, the sheriff's office, it's their job, it's the courts, it's not the prosecutor's job. That is an insane argument to take what was stated and to say, and to manipulate the wording and to pretend like they're not supposed to. That's just nuts. William, thanks for the 10 there. Every time Dan Owens refers to email, he admits the part about advising, the sheriff's office from enforcing the protective order. A generous interpretation is that it's misleading. In reality, it's attempt to defraud. Of course, you're 100% right. Yeah, they want to, when they're defending them, they want to pretend that what was stated there was somehow typical. Not only that it was in his purview, but it's typical. Hey, the first thing that I'm going to do in looking at this protective order is to investigate the victim. That's so atypical. Why would you do that? Why would you do that? And why would you, not only would you do that, but why would law enforcement, why would they have this conversation like that if they're thinking about enforcement? Again, he threw them under the bus, though. I thought that was pretty fascinating. What's up, on dude? Thanks for the 5 there. This sounds like the argument about how law enforcement doesn't need to protect you. Yes, indeed. That's exactly it. Washington v. something. Yep. It does, doesn't it? We're not responsible for your protection. Yeah, it's a horrible argument, isn't it? It's also, again, like the whole argument of not, I didn't know that was illegal, therefore, within the qualified immunity statute. That's terrible. It has to be so well established. Like I said, you try that as a citizen. You try to argue that, well, I didn't know that was illegal. You see how that works out for you, because it doesn't. Here's a newsflash. They will arrest you anyway, and you will be prosecuted. It's only when authorities get in trouble that's somehow a valid argument. It's wild, isn't it? What's up, Greg? Thanks for the 10 there. I just spending my vacation money in Tennessee. Indeed. Hey, Tennessee's a great place to chillax, by the way. Being from here, I enjoy Tennessee. Like I said, I like it. I've lived in other places. It's a good place to vacation. Just stay out of the main. One thing I would advise, though, if you come to Tennessee, unless you're going there just to check out something in the daytime, I would stay out of major cities. You can go to Nashville. It is a tourist place. But make sure you stayed in the right places. Absolutely avoid places like Memphis. Do not go near them. Memphis is a terrible place. It is a terrible, dangerous place. People that are from Tennessee, they avoid it like the plague. But yeah. So, Cindy, thanks for the 5 there. If prosecutors won't prosecute, it's a waste of police time. Yes, indeed. And they contact. Like I said, I've been there. I've talked to police about that. That's what they do. They contact to see if they're going to, number one, if they will press charges, but also beyond that, if they're going to prosecute. If they won't allow them to press charges, then there's no arrest that's going to happen, period, right? But beyond that, if they're not going to pursue charges in the aftermath, then why would they waste resources? Because it's very limited. They have very limited resources. And one of the crazy things too, is that protective orders, they don't make headlines. You can't lay it out on a table and, measure it like they like to brag about. They love to brag about drug busts and more. Why? Because you can see something tangible. They can say, look what we did. They can show seized material. They can't brag about enforcement of protective orders. So prosecutors don't like that. They don't like to do that. But it does matter as far as the person that has a protective order. It absolutely does matter, to the individual. And I would say, even going further, it matters to us as citizens, because we could be the ones with that. So when we look at it, it does matter, but they don't think it does because it won't get them elected, But yeah. Lynn, what's up? Thanks for the 10 there. Dedicated lurker here. Happy birthday song to a partner's daughter and saying happy birthday to their 96-year-old grandma. And we'll look at it briefly, 3 a.m. here. It's now my birthday. Yes, well, it's your birthday. You know what? You need this birthday song. You need it in your life. And if you've gone to sleep, I hope you catch it in the aftermath. Here we go.
Happy, happy birthday from both of us
All
to
of it.
you. Happy, happy birthday.
Happy birthday.
May all your dreams come true. Happy, happy birthday. We love to have you here. Happy, happy birthday. Here's to
And here's to
another
1 million
year.
wonderful. Yeah. Love to you, though. Appreciate you. I hope you have a great birthday, too. Hope it's great. Max Lab. So the judge is Alan C. Windsor, referred Buchanan. I'm gonna look at the judge. I'm curious again with this kind of stuff. Like I said, they oftentimes look at immunity cases and they see themselves in it. So how will this play out? Well, it'll be interesting to see. Well, we'll see. I just, you can hear in my statements, I don't have a lot of faith in it, but we'll see. What's up, Queen Bee? Thanks for that. I don't know if this went through yesterday. I was wondering if you were going to be on Thanksgiving night because of my birthday. I'll be 70. I love listening. Yes, I will. I don't know how long I will be on that night. I will be there, but you know what? I will also bust you out a song today. That way, if you for some reason are doing something else that day, if you're out there, you're partying up, whatever you're doing, let me bust you out a song right now. But yes, I plan on being here as long as nothing, unless fate conspires against me. I plan on being here. If everything works out for sure.
Happy, happy birthday.
Early birthday.
From both of us to you. Happy, happy birthday. May all your dreams come true. Happy, happy birthday. We love to have you here. Happy, happy birthday. Here's to another year.
But yes, I try to be on every day, regardless of holidays or anything else. Typically everything by this time at night, everything like even like Christmas or anything else. The only date that's an exception to that sometimes is New Year's. Sometimes with the New Year's, you have a later day. Although I don't, I spend my time with family. I don't go out. I don't party or do anything crazy like that. So, but sometimes, with the fam, I hang out on those days. But most holiday, like I said, I try to live stream every time because it's like this. I feel like with it, number one, not everybody has a place to be, but you know what? You do have a place to be. You have a place to be right here. This is your place. So I try to do that. Now, I don't succeed every time, but I do try. Rearrange things for the two there. We need the unbirthday song for Rebel. That's right. It's your not birthday, right? A very very birthday to you. That's right, man. You need one of those. I love it. Thank you, Ria. Right, I appreciate that. Emma, thanks for the 10 there. Owens and attorneys lied in this filing. Cook was arrested for the pew pew, not for pulling it on Jeremy. That's right, for pulling it on Tube Town. Well, that's an interesting little thing, a little dilly too. I think when we get down to arguments about it, it'll be, like I said, it'll be interesting to see the challenges brought up, and truly, it'll be interesting to see how the court reacts, because courts, they have to be open to doing that. And again, ecosystem wants to celebrate anything terrible that happens to Hales. They've been complaining a lot about the removal of identity. I don't refer to them. Sometimes I'll refer to them individually, but when I post or when I put up a thumbnail, I refer to them as anti-Hales. That's all they are. They're not individual. Their actions aren't individual. They work as a collective. They've grouped up, and they absolutely have done it to harm, this one guy. So they will celebrate anything horrible, including something like that. But it just shows who and what they are, too. They will celebrate just anything terrible. All right, Lynn, one other. What's up? Hey, Jordan, thank you, my friend. I appreciate that. I saw $10 through Cash App come in. It's for keeping it coming, sir. Well, I appreciate that, man. I enjoy this. Like I said, I enjoy getting together with all you folks, having a good time, too. I mean, that's to me, that is one of the more important things. Like I've been I've been privileged, to be able to do this. So I enjoy it. I can't even tell you how much I freaking enjoy going through. You can tell I enjoy covering like something if I find it and start covering it. Let me do a redirect, by the way. Tonight, it is a Saturday. So as always, I redirect to Flashcast. Now, I note with Flashcast, if you are easily offended, that is not the place for you. But if you want to go laugh at whatever stupid nonsense has come up socially, politically, or more, it is definitely the place for you. You will have fun with it. And, again, the people that are there, more than anything to me, that's why I do that and shout them out. Because at the end of the day, when I've ever needed anything, those guys over there, the main folks like Yellow Flash, I would say, I don't say this very lightly. Yellow Flash is a friend of mine. So I've met him online. He's stood up when it counts every time, not when it's beneficial, but when it counts. And a bunch of other guys over there like that too. People like Tom, Agent Rhino, all those guys. But, I don't know everybody there, but the ones I do, appreciate them. So if you want to go goof off, have fun, go over there. I appreciate you. But I'm going to end here. Now, tomorrow, we will be live again. When we are live tomorrow, keep note, I will be early. We start out early because Hales is on at the normal time here. So we'll cover. I'm planning, unless something else pops off, I am planning on talking about them taking aim at Silverman. Preston attacks her own lawyer. I think that's fascinating stuff. But anyway, I will see you. Thank you.